Huh. Hmm. The steps to 81 out, huh? Miss M. Kumari, when a council is paying for the, you are paying for? CBI has submitted that although the steps have been taken on the respondent number 1 and 2, only the respondent number 2 has appeared through your name, sir? H.L. Moria, learned counsel. Accordingly, list the matter again on 23rd of March. Sixth? After beautification. On 21st of April, 2026. Waiting. Pleadings may be exchanged in the meantime. Yes. 53 and 54. Yes. Whatever be the reason. Whatever be the reason, charge sheet is not coming up today. So 53 let us first dispose of. The heard Mr. So-and-so learned counsel appearing for the petitioner, also heard the learned APP. Today is the 60th day of detention for the petitioner. One petitioner. Two petitioners. Namely so-and-so and so-and-so. What is the allegation? The learned APP has submitted that the charge sheet has not submitted, although it is 60th day today. The charge sheet could not be submitted because of since the investigation is not yet complete. The petitioners are aged about 18 years and 21 years, and the keeping in view the length of detention, this court is of the opinion that the petitioner can be released or requires to be released on bail. Accordingly, the petitioner number 1 and petitioner number 2, namely so-and-so, so-and-so, shall be released on bail on punishing bonds of rupees 50,000 each. 50,000 each with 2 sureties of the like amount, to the satisfaction of the CGM Kamrup. Kamrup. The learned magistrate shall be at liberty to impose such other conditions as may be required to ensure the participation of the petitioners in the investigation and in the investigation of the matter. List of bail applications stand disposed of. So, in the earlier order, we said that the investigation is not complete. In the second one, you are saying almost complete. Then we'll cancel it and we'll put it up for tomorrow. The learned counsel for the petitioner has submitted that the other co-accused who were taken into custody were not sought for police custody, even on their arrest. And today, by an order passed in BA number 534/2026, they have been granted bail. Accordingly, he has stated the present petitioner may also be granted the pre-arrest bail, full stop. The learned APP has submitted that because of the non-cooperation of the present petitioner, the investigation could not be completed within the stipulated period, huh? The from one bathroom. Whose bathroom is it? Ah, the learned APP has submitted that the recovery had been made from the bathroom of the house alleged to be where the petitioner was residing. Full stop. The learned counsel for the petitioner has objected to the same. Full stop. However, in the facts and circumstances, this court is not of the opinion that the petitioner in this case can be granted the privilege of pre-arrest bail. Full stop. Accordingly, the prayer for pre-arrest bail to the petitioner in connection with is not entertained at this stage. A be disposed of. We should participate.
Item 58 and 59.
Yes, sir. Case diary is awaited. Hmm. Hmm. The injury was granted on matter 412. Hmm. Then why this bail petition? Some little cost. Should we impose some cost for having wasted the court time? On when? When? Dated. Page 21. When? Give us the date. Yes, why on 8 December 25, sir? Mr. Bushel and APP has submitted that the charge sheet has been submitted in the matter. However, on wide CS number. The learned counsel for the petitioner has drawn attention of this court to the annexure number 4 at page 21 of AB number 2871 of 2025, by which the petitioner we'll do. The learned counsel for the petitioner has drawn attention to the annexure 4, by which the petitioner was required to appear before the investigating officer by 8/12/2025. Full stop. The learned APP has submitted that the notice was issued on 26/11 and the charge sheet was submitted on 29/11. And thereafter the petitioners had appeared or have approached this. And after the petitioners, no, after the charges was submitted, the petitioner had appeared before the IO. We'll stop. A complete report on the matter be placed before this court on the next date fixed. The interim order passed earlier shall continue till then. List the matter again on the 26th of March. Not necessary. We just want to know whether the charge sheet has been actually submitted or not. That is why I've called for a report from you. We have called for a report from you on his allegation that he was required to appear on the 8th of December and you filed a charge sheet before that. Give us a complete report. He appeared on so and so date. We informed him on so and so date. If he has come to this court with an AB after knowing that the charge sheet has been filed, we shall see what can be done in the matter for wasting the court time. What to do, madam? They have submitted the charge sheet. What to do? Call for the TCR or you want to approach there? The learned APP has submitted that the matter has culminated in charge sheet number. Huh? No. 02/26. We remember hearing earlier also. 1 of 26 and 2 of 26. 2 of 26 is. 2 of 26 আগতে এবাৰ গৈছে না? Oh, PS will be different. Yes. Yes. CS number 2 of 26. Just a minute. CS number so and so dated. And full stop. When was your bill petition rejected? The learned the learned counsel for the petitioner has submitted that the petitioner may be allowed the opportunity to approach the learned trial court. Stop. Prayer is allowed. This bill application is closed. If the petitioner applies for regular bail before the learned trial court, the same shall be considered on its own merits without reference to the dismissal of this BA.
17.
Yes, sir. Huh? Huh? Yes. Call for the up-to-date case diary. We had rejected the AB earlier. Call for the updated case diary. They'll put the details. Do we need to say it or you'll put it? They'll put it. 19.3. List again on 19th of March.
39.
Yes. Dioksu, 3টা order আনিছে. Yes, what do you say? Hmm. Hmm. Ah. Huh? CDN has several? Huh? Now for that we will give you three sentences. For that we will give you three sentences. First, it has been held that confessional voluntary statement of the respondent or co-accused will not be used against them. Just a minute, just a minute. Go one by one. We heard you. Messages retrieved from the cell phone are not clear that they were regarding the contraband. Your phone calls do not say that they are regarding the contraband. It was only in the area. And the third ground that you took was there is no there are no reasonable grounds for believing that the petitioner is not guilty of the offense involved in this case. It is to be taken note of that no material record suggests that the petitioner was involved in the similar offense on earlier occasion, or there was any other material to show that if the petitioner released on bail is likely to commit any offense while on bail. Therefore, the embargo is not applicable to this case. Hmm. Same. 37. Huh. There are Supreme Court judgment which says that even the custody will be given, the Zimma will be given if he was not riding it. He is not there on the bike. Then, huh? Huh. For circumstances. You are not being able even to show from the CDR that Hmm. 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 Nurul and Narul, there are two of them. Or there is only one. Huh. And he was granted bail. Huh. Huh. Yes. It is not because of technical. Kindly have page 52. He was taken into custody. You did not produce him. Hmm. What about page 47? Page 47, what is the last line, first paragraph? No, no, I am reading the topmost paragraph, last line. Moreover, uh, who is Nurul? How many Nuruls are there? No, oof. Just a minute, just a minute. Place of the matter. Where is your home? No, no, Nurul, Nurul. Hey, you don't have to tell me whether you are Nurul or not. You have to tell me. No, 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 no. There was another Nurul from Botorosi, and there is another Nurul Haq from Jagannath. Ah, there are two Nuruls. No, no, something is wrong. Where is the FIR, the name of persons? 1-5. Do you have the CD with you? Scan copies. Page 15. Show us Nurul. See. One is Nurul Haq, 40 years. One is Kalamuddin, page 16. One is Salamuddin. And one is Nurul from Botarasi. Huh? So this is one Nurul. Salamuddin. That is what I'm saying now. No, no, I'm thinking on another line. This page 50, when we granted the bail, was it a confusion between Nurul from Botarosi and Nurul from Jagannath? Huh? Where is the forwarding of these two persons? They were all arrested together. Who? Salam. No, no, these two Nuruls were arrested together. What about the other Nurul? Huh? No, that is okay, but otherwise, these three orders.
I am from Bhagwat Road. That he was from Jagannath, which is nearby me. He taken my motorbike madam to go to the ASTC master to take to become one day. So my I told him why my bike was not given. So there was a contract.
We'll pass our orders. We'll take into account the judgments you have given. We'll pass our orders. We'll give it to
70.
Huh? From where have you asked it? Huh? Pulibor. You are already under protection. List again on. What is this IA for? Son of. List again on. Day after tomorrow. 11th. Awaiting the report called for by the earlier order of this court. Interim order continues.
73 and 74.
They assaulted a child. When do you want it? List again on 26th. 26th of March, awaiting the up-to-date case diary. Mr. S.C. Biswas, Learned Counsel, appearing for the petitioner, has submitted that the petitioners have appeared and participated and cooperated in the investigation. Interim orders to continue. Ah. Ah. In item 73, give his name that he has submitted. Yes.
75.
List again on 23rd of March. Interim orders passed earlier to continue. Twenty-third. 26th, 26th. 73 and 74 together, 26th. 75 is 23rd. What is the allegation? None of them reached the location. That is the. Huh? Uh, but they say that some of it was damaged. That is the case where it was damaged and they could not. In the rain, it was damaged. Hmm. It's 22/2026. Nearly 1 month. When, sir? Nineteenth? He has given photographs of the damaged cement. Huh? Heard Mr. So-and-so learned counsel appearing for the petitioner also the learned APP who has submitted that the case diary is yet awaited. Full stop. The allegation against the petitioner is that the he being a transport, he is a transporter. He being a transporter, some amount of cement had been given to him for transportation, but they did not, but the trucks which were carrying the cement did not reach their destination, and accordingly, the manager of a transportation company had lodged the FIR against the petitioner herein. Full stop. The learned counsel for the petitioner has submitted that although it is a fact that the cement was being transported through the petitioner, due to heavy rains, a lot of cement had been damaged and therefore could not be delivered at their destination. Full stop. Awaiting the case diary, this court deems it fit to allow the petitioner to participate in the investigation process. Full stop. As such, the petitioner is required to appear before the investigating officer on or before the 13th of March 2026 and participate in the investigation. In the event of his arrest, he shall be released on bail of rupees 30,000 with one surety of the like amount subject to the satisfaction of the investigating authority. The updated case diary be made available to this court invariably on 27/3/2026. 57 for hearing. Hearing one. তার আগতে কি আছে? Orders কি news আছে? Yes, you want to do it today? The appellant has expired. Ah, yes. Close it. Hmm. The learned counsel appearing for the appellant has submitted that the appellant has expired. Stop. Accordingly, this criminal appeal is abated. Stop. Return the LCRs. Item 78 for orders. Ah, Hmm. What was the matter? She had suffered a fire burn, and her regular period of absence was regularized.
Her name was
Ah, ah.
the ground that the recently your system now negative policy.
Hmm. Hmm.
It was has already gone to the good field. Does not stipulate particularly the first.
Oh yes, we went through the rules. For recruitment, the rules said graduation, but for is it that case? No, for recruitment it is graduation, but for promotion, hereinafter was the word used, and in that hereinafter part there was no graduation. That is how we remember it. That is that case. Ah, okay. Yeah. Oh. Now he will come and say that he has to file an affidavit in opposition. Now, but you have already filed an affidavit in opposition.
Pilot was like 68.
Hmm.
We have already seen 123 on. We have provided it before, prior to filing of this petition. We have done our.
Now you are appearing for WPT and BC. So your affidavit is on record. Hmm. Hmm. List again on 13th of March, showing the name of Mr. R.M. Das. Then all your arguments on that day, we are closing the tap. No argument, no further argument will flow. Because you have done your part, you agree to it. Hmm. You have said you don't want the promotion to be given. You
Now, they are bound by any ballot. If registered ballot is released.
press recruits. List again on it, 13th of March, showing the name of Mr. R.M. Das, Learned Counsel appearing for the Social Justice and Empowerment Department
In the admission.
in the admission column.
Government gets me a problem. We have already provided prior item of the report.
So his grievances against respondent number 1.
Government will say that you don't have anything in the matters of corporation.
Then it will be a big weight on his shoulders. Yes.
Item 80.
দুটা ৰুমত দিবলগীয়া আছে 3টা. Item 80.
Item 80.
Steps have not been received. 5-3. Fresh step has not been received. Mr. K.K. Parasol, Learned Counsel, Learned APP, praised for 2 weeks time to take fresh steps. Stop. Allowed. List again on 24 April with service report. 2023, it was some LP. Are you serious in pursuing it or not? Huh? No, is the state serious in pursuing it? Etup koi daur pani puri, huh? If you can remove it dropwise, our burden will be less.
Sorry, 81.
Next occasion, we are not waiting for any fresh steps. We will take the steps. Yes. Huh? 81? Mr. Parashar, the order of this court on 10/6/2025 says it is hereby directed that further proceeding in sessions case shall remain stayed. Now, the session judge says accused persons have prayed to stay the proceeding till an order is passed by the Honorable Gauhati. Does he fail to understand English? Huh? Hmm? Your name, sir? Hmm. Heard Mr. D.K. Boyddo, Learned Counsel, appearing for the petition. Also heard Mr. K.K. Parashar, Learned Additional Public Prosecutor, appearing for the state of Assam. The order dated 10/6/2025 passed in criminal petition number 652 of 2024 is quoted below. Huh? Quote the order, huh? Full stop. The proceedings in sessions case number 78 of within bracket NL/2021 was directed to remain stayed until further orders. Full stop. The order dated 4/2/2026 of the learned session judge Lakhimpur, not Lakhimpur, passed in sessions case number 78 NL of 2021 records that the accused persons were praying to stay the proceeding till an order is passed by the Honorable Gauhati High Court. Full stop. The order dated 10/6/2025 was already available before the learned sessions court in through certified copies submitted by the accused persons / petitioners hearing. The reason for continuing the proceedings in 78 NL of in sessions case number 78 of within bracket NL of 2021 by fixing the matter for appearance and submission of status report and submissions of updated copy of order of the Honorable High Court. At this stage is not found to be necessary, since all proceedings in the sessions court was required to be stayed until further orders, full stop. Learned session judge may take note of this order and stay the further proceedings in sessions case number 78 within bracket NL/2021 until further orders vacating the stay or allowing the court to proceed are placed before it either through the registry of this court or by certified copies to be given by either of the parties to the case, full stop. Yes, now tell us, what is this petition about? Mm. Mm.
That the deceased person be a household help at the house of the petitioner's brother. Petitioner from one father. The head of the house.
Mm.
Then prior to any for prior question, they want to examine. And when the IO happened last week, he was examined. But the audio visual set clearly. But those audio visuals at the time of furnishing copies of the 2007, those were not made available to the accused.
Mm.
So they sought for copies of the same. When it was displayed and said, cross examination those copies will be furnished to them. And accordingly, I will be examined. That was not allowed, and I was examining and discharged them. So subsequent, before the level for recalling the re-examining the IO, only the extent of those audiovisual files, which was disallowed by law. Subsequent, which by law, we having no other law. The petitioners approached this honorable court, and as because by law there are no other witnesses, that all has been already examined. The point of law that has been decided is the better to copy of the furnished at the IOD report. From that aspect, right?
Yes, what do you say? Evidence which was not furnished to them, that was brought up in the during the evidence. Would they not be entitled to copies and a cross-examination on the same? Yes. Huh? When? When? You pick a date, we'll fix it for hearing. Pick a date. Small issue. Nobody can be faced with a part of evidence, with an evidence of which he has no notice. 24th. Then below that you write, list this matter again on the 24th of March. Yes, sir? Choose a date, pick a date. Yes. 7th. 7th, on the 7th of April. For hearing. Full stop done it. APP is requested to be prepared. Both the councils are requested to be prepared for final consideration.
83.
What is your ground? How was it determined? It will be orders or executive? Orders or executive? Where is that? Where is that part that only the? No, you show us from the judgment that the age has been determined only on the page 27. Victim was born on 5/8/2022. Eh? And you are saying 18? Born on 5/8/2022, page 27. Or am I reading it wrong? Hmm. 5/8? What should it be actually? What should it be? 2019. 21/12, huh? And where is how does the court believe the age? Huh. What is exhibit 4? How was exhibit 4 proved? The health services were not called in. She gave her matriculation examination, school certificate not called in. Huh? 17 years something. She says I have appeared in the matriculation. PW2 mother says appeared in the matriculation. And the birth certificate not proved in accordance with law. When? Service not complete. We were about to dispose it of. Await service report on the respondent number 2, list again on 23rd, 24th of March. 24th. Huh? Sir, 5/3, it says service report has not been received. You have to give, I think you have to bring it. Then you bring it by 16th. If the service can be completed, we can have a amicus. Huh? List again on the 16th, allowing the learned APP to inform the court about report of service on the respondent number 2. You have your judgments ready.
24.
Yes, sir.
Wow.
Huh. Huh, huh. Huh, but para 10 we are trying to trace up. Just a minute, sir. Just a minute. This is para 4, then 5, 6, 7, 8, 9, 10 per contra.
Yes. Then report of 2020. And the ratio that thereof must be declared to be RL. That was his submission.
Huh.
That code, the apex code, paragraph P, 7.
Hmm.
Especially makes the provision of CLSS applicable to the proceeding before a special court, insofar as they are inconsistent with the provision of the yes. Consequently, the powers under section 4 of the CRPC pertaining to the disposal of property pending trial would certainly apply to the proceeding before the special. In the absence of an express bar under the NCPA said, the beer offense is a vehicle may be liable up to 60. Under section 60 cannot by itself deny the individual custody to a bona fide. Although the rules is there, madam, say that
It is that case where this person was escorting. And you are one he is one of the accused. The owner is one of the accused who was escorting it by the other vehicle. Uh, you are the accused and your vehicle was being, but it was being used in the trade by as a decoy. Hmm. Hmm. Charge sheet is filed. We need to know why the vehicle needs to be in your possession when the vehicle was not used for carrying the contraband and was escorting, and the allegation is that it is escorting the vehicle which was carrying the contraband. Eh? If you have this order by which it was rejected, page 35, do you have a copy? Page 35. Hmm? Huh. Huh? Now it is a submission of the petitioner, learned counsel for the petitioner, that when I may be accused, but when the vehicle is not being used to escort, or vehicle is not being used to transport, and I'm only traveling it in and I'm only a suspect, can my vehicle be still allowed to rot away in the police station? There is nothing in that vehicle. And the issue that was raised on the last occasion is this vehicle is a decoy, it is a full participant in the trade. The owner is an accused. Should we release it? Is what the prosecution has raised, and therefore this Danish has come into play. No, that is fine. But those four conditions, that on these conditions it can be released and on these conditions it may not be. No, that is what we are trying to find out, whether in this condition where it is not actually transporting, should we release it? The person, the accused himself is on bail. Is not helping anybody. Eh? Heard Mr. NJ Tolerant Counsel appearing for the petitioner also heard the learned APP. Mr. K. Parashar, full stop. By this petition, a prayer has been made challenging the order dated 16/7/2025 passed by the learned additional session judge number 5 Kamrup Metro whereby the Zimma petition filed by the petitioner had been dismissed, and a further prayer for passing necessary orders for release of the car of the petitioner, being Maruti Swift ZXI Plus bearing registration number so and so, which was seized in connection with NDPS case number 187 of 2024, corresponding to STF police station case number 20 of 2023 under section 21C/25/29 of the NDPS Act, pending before the court of the learned additional sessions judge number 5, Kamrup Metro, Gauhati. Stop. The story as revealed in the petition is that the this is your bail petition, this at page 17, sir.
Yes.
I take it down. The petition, the factual matrix as reflected in this petition is that an FIR had been lodged before the officer in charge, STF police station, alleging that on the same day at about 7 a.m. on 28/11/2023, comma, an information was received regarding transportation of narcotic drugs from Manipur by a Tata Yodha goods carrier vehicle towards Goripur area. Full stop. The Tata vehicle was to be escorted, was reportedly escorted by a Hyundai Creta and a Maruti Swift car bearing registration number AS15/P 2222. Four twos, huh? Full stop. The petitioner in this present petition is the owner of the vehicle of the Maruti Swift car. Full stop. The petitioner had also been taken into custody on 10/5/2024, and the vehicle had been recovered from the spot, allegedly when the petitioner herein had abandoned the car when it was stopped by the authorities. Full stop. This court by the order dated 20/5/2025 passed in bail application 1170 of 2025 had granted the petitioner bail, noticing the violation of the constitutional rights of the petitioner during his arrest. Full stop. The petitioner is now on bail. Full stop. Next paragraph. Having been released on bail, the petitioner had moved an application for Zimma of the petition, or Zimma of the vehicle, bearing registration number AS15P 2222, which came to be rejected on 16/7/2025. The grounds for rejection of the Zimma petition is found at paragraph 12 onwards. Full stop. Take it from page 34, huh? Thus, the reason for disallowing the Zimma of the vehicle to the petitioner herein was that the owner of the vehicle was an accused in the instant case, and the allegation was that the vehicle was used for escorting the safe transportation of the seized contraband. Full stop. The learned counsel appearing for the petitioner has placed reliance on the case of Denash versus State of Tamil Nadu, disposed of on 27th of October 2025 by the Apex Court, stating that the rules of 20, the rules, what rules are that? No, no, what is the full name of the rules, sir? That the narcotic drugs and psychotropic substances within bracket seizure, storage, sampling and disposal rules 2022 were held. Wherein it was held that the so-and-so rules cannot be interpreted as divesting the special courts of their jurisdiction to entertain an application for interim custody or release of a seized conveyance under Section 451 and 457 of the CRPC, within brackets sections 497 and 503 of the BNSS. Full stop. The authority of the special court to pass appropriate orders for interim custody as well as to make final determination upon its conclusion continues to operate independently of the disposal mechanism envisaged under the said rules. Full stop. The learned counsel for the petitioner thereafter has placed reliance on paragraph 29 and 30 of criminal appeal at the rate SLP criminal number 8698 of 2025, Vishwajit De. The question given. Hmm? What is the quotation, sir? Hmm. Again? Hmm? Reported in so and so. To contend that since no recovery had been made from the petitioner who is an accused, and furthermore, there was no recovery even from the vehicle in which the custody of which is being sought, the vehicle requires under the vehicle can be released on Zimma to the petition upon strict and sufficient conditions being imposed for its production during or at the end of the trial. Full stop. In the present case, this court notices that the petitioner is on and has been granted bail by this court, the other vehicle, that is the Hyundai Creta, which was also escorting which was also allegedly escorting the vehicle from which the contraband had been recovered, has been released on Zimma, and no recovery had been made from the vehicle which is for which the Zimma is not being sought. Full stop. Accordingly, and the learned APP has submitted that since the petitioner is an accused and the vehicle was used as a decoy oblique escort in the transaction of contraband items, the same is not required to be released on Zimma at this stage. Full stop. Next paragraph you write, we have given This court has given anxious consideration to the submissions made, full stop. This court has already noticed that the petitioner is already on bail, although an accused, comma, no recovery had been made from the vehicle concerned, and furthermore, the other vehicle which was allegedly escorting the transportation of the seized contraband has also been released on Zimma, full stop. In the facts and circumstances, comma, this court does not see any reason why the vehicle should not be allowed to be released to the petitioner herein, so that the same can be maintained and kept usable in case the vehicle is at a later stage found to be not required either for confiscation, full stop. Either niche, yeah, is not required for confiscation, full stop. In such circumstances, this court directs that the vehicle bearing number AS 15 P 2222 be released to its owner upon proper identification and after following such due process as is required in law during the allowing the owner to retain Zimma of the vehicle during the trial of the during the trial. Full stop. The Zimma shall be allowed subject to the following conditions to be fulfilled by the petitioner. Zimma conditions will come in, and thereafter you say the learned trial court shall be also entitled to put on such conditions for release of the vehicle on Zimma as may be deemed necessary to ensure the production of the vehicle during or at the culmination of the trial. Stop. Criminal petition disposed of.
For admission, item 23.
Just a minute, sir. Yes, sir. TC এখন আহিছে আহিছে. What about the other what about the respondent, private respondent you are appearing? Yes. The TCR has come. Let us admit it today. Today is a Monday. We have a long list, so we'll fix a date for hearing. Heard the learned counsel for the parties. Admit list on when 19th. 19th or when? Tell us. 31st of March in the hearing column. Interim order passed earlier continues. There is a stay.
24.
Hmm. 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 Hmm.
Paid for and second, then was prejudice now to the trial. Because the cases for the under mortgage CRT main.
Hmm.
So now they are alleging something which because we do extra documents. We do cases. That is why we find this petition before the tribunal court for submitting an additional affidavit invoking all those, but that was not allowed.
Ah. Hmm.
Now the case is that the AW is the cross of the video.
Hmm.
But should have break we have to see that as those questions on record. The petition which we have filed for the family court, that's for the.
When is the next date?
He cannot come for, we cannot come for,
You are appearing for the. You are the husband. You are the husband. And you are informed, you are already informed that the lady would not come. Oh no. Your witness is not coming. Hmm. Already there is an order for payment of 14,000. Ha.
he cannot be terrible. Unofficially, he is saying that he has left his son in a Venezuelan house, and the daughter is with, and she put the daughter in a homestay. Initially, they were there. His daughter was there. She put the daughter, and she is enjoying the entire maintenance for the son and the daughter.
None appears for the respondent. Hmm? None appears for the respondent on call. Admit the matter. List again on 24th of March. Right? 19th of March in the hearing column. Ascend 19th. Oh, 19th, no. It has to be, it has to be 24th. We have exceeded the other dates. 24th in the hearing column.
Till 25 to 38.
Huh? Huh? Yes, Mr. APP. Hmm. Hmm. Oh, that one where they want to go, but they are not being allowed to. Hmm. Why do you threaten people? Yeah? Huh?
Police station also one. What email?
He did not reach the court premises, is what he's saying. Yes, madam. Why did you not take steps on that day itself? Hmm. 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 Proceedings are under stay. Eh? We are going to vacate it. You go and you give your evidence. You give a intimation to the PS. You give an intimation to the PS that you are going for evidence. The police will, at your cost, they will give you the escort. You go and you give your evidence. Huh? Give your WhatsApp location to the officer in charge. Keep driving your vehicle, enter the court premise. Again, give your WhatsApp location. Come back to Guwahati. He is swearing on oath. He will not do anything. Hmm. Hmm. No. What is his age? 65. Huh? 65 years. What is his age? How old is he? 68. Give the money. This is an act. Give the money. Why did you take? Eh? Not even second class, first class contract. That first class is because of his work done or because of the classification of the amount of work done. Then you can also have your private bodyguards. 64 crores, take your private bodyguards. Huh? Keeping this matter hanging like this is not working out. What is the interim order? What was the interim order? Kindly tell us. In which case? Transfer petition number 8. Yes, we have 8. Show us the interim order. Yes, madam, quickly. I will tell you what is the interim order. Interim order will be considered. What is the interim order now? There is no interim order. Hey, file kita diok. Please find out what are the interim orders. Next to Matok. Good, look through them. Please tell us what are the dates in each of the case where there is interim order.
Item 41.
Kita আছে এটা order niki? এটা admission. Huh? Yes. Huh? Who has informed you? You are for the amicus curiae. At the request of the Honorable amicus, list this matter again. When? 19th of March. Huh?
42.
19th নহয় 19th নহয়, make it 24th. আকৌ দিয়ক 24th বুলি তেওঁক 19th নহয়. Item 32. Yes, sir. Yes, sir. Huh? Huh?
Under section 320.
Hmm.
Page 25.
Hmm.
Running page 25.
Hmm.
There are three persons, two persons, where acquitted and one was convicted. The motion might have got page 25.
Yes.
And so I convicted him only for offense under section 320. IPC offenses under are not proved against and the accused intercede and still not convicted for those offenses. The prosecution will be to prove the charges under section 1 IPC against the accused person.
What is your ground?
As the acquitted. Last only, the Gunita was convicted under section 323 and he was imposed a fine paid paragraph 45 your lordship. After hearing the accused of
1000. Yes, we have seen that.
fine.
Huh?
Against that, the human side filed an appeal for the addition.
Hmm.
And now the addition session judge in respect to the other accused that is Mohan Shield and Kishu Shield is the father and son,
Huh.
the accused will remain.
Hmm.
In case the Shield was given the conviction of 323, he was demanded of intercession not specified.
Hmm.
That is, according to him, the sentence is alien, it should be imposed. So, your lordship, I beg to close your lordship attention to page 45, running page 45,
Huh.
page 44, paragraph 44.
Hmm.
For the reason just herein above, it is crystal clear that the active bears married and accordingly the appeal is allowed to contest of the improved judgment and the border path by the learned court below is declared. And the substantive path by the learned court below is set aside and remanded back the case to the trial court. The trial court would consider circumstances under which the crime was committed, the extinction and aggregation, the nature of the offense, whether there was remediations and other material circumstances including duly sustained by the victim and the passing of future death recording. That is, the learned required statements are not satisfied to the conviction and sentence given by the trial court of 326 under section 323 and final to So, my lord, now we will again take judgment to the file the sentence of 1000 has already been before the government. And as for physical condition, I beg to call your lord's attention. Page 49 and 50, my lord. Last page, the last two pages, he is physically handicapped, my lord, because of taking, and he cannot move. Even the last offense was your offense.
What she has done in when she could move is dangerous enough. Hitting a small girl with a stone. Huh? Is it not?
There was a different quarreling between parties. Children in front of their house, that tower,
Hmm.
and incidentally there was a stone, and she was given the day that the stone fall fell on the forehead of the and because of which even the medical, there was no medical examination. Doctor was not examined.
Yes.
During trial, the doctor was not examined Whatsoever might have we admit, incidentally, opponent proved to it, and there was a duty, was given this conviction. Now it will be.
Now, what is wrong with this?
Not conviction, sentence given. So it should really be higher. So I made the respectful submit before a lawsuit filer. To be a due lawsuit done, that sentence may be enhanced. Matter may be closed here, so demanding back the matters for retrial. There is no order for
Yes.
retrial event. No order for retrial event.
Only the punishment needs to be enhanced.
Enhanced.
How much? How many stitches? How many stitches the child got? Where? Then, tell us how many stitches? 500 per stitch. Yes. How many stitches?
Has already been reported.
Yes, Piki, what do you say? Two families fighting, one throwing a stone. Huh? Neighbors.
On the house there was people lying on the street because the children were fighting, quarreling with different. Incidentally, one stone.
One stitch. One stitch. Page 18. She had to take a stitch. So a stitch in time saves 9. One is good enough. What do you say, Mr. Boysha? How much? Suggest he is agreeable to pay an enhanced fine and finish it off.
Physical condition.
Tell us how much.
I leave it to lawsuit.
First things first, minor girl should not be there. Her parents will also pay some fine for allowing her to go and fight. 2011, 1000. Okay, we'll make it 3000. Building. Okay, heard Mr. M.H. Mazhar here. Rajbur here. For the petitioner. Also heard Miss S. Nazneen, Learned Counsel, paying for the respondent number 2, and Mr. Boyso for the as the APP, full stop. The challenge to this, a challenge in this petition is to the order dated passed in criminal appeal number, full stop. The crux of the matter is that there was an allegation against the petitioner herein that during a argument which resulted in a fight between the petitioner herein had hurled a stone at a minor girl which injured her on the forehead, causing a lacerated wound of 1 centimeter into half centimeter over the right forehead, and in the opinion of the doctor, the same was simple in nature, caused by a blunt object. The learned trial court, after considering all the evidence, had found the petitioner to be guilty under section, guilty of an offense, 323 of the IPC, and while refusing to give her the benefit of the Probation of Offenders Act, had sentenced the petitioner to pay a fine of rupees 1,000 in default thereof simple imprisonment of 1 month to be given to and the fine 323 in default there in default simple imprisonment of 1 month full stop. The fine amount if deposited was to be given to the victim of the case full stop. The appellant the informant in the matter had filed an appeal registered as criminal appeal number 224 of 2017 in the court of the additional session judge number 1 Kamrup Metro Gauhati full stop. On the appeal being taken up for consideration, the learned appellate court had found the sentence to be not commensurating with the gravity of the offense and therefore had required the petitioner to appear before the trial court again, and the trial court was directed to consider the circumstances, the extenuations and the aggravations, the nature of offense, etc., and pass an appropriate sentence in accordance with law against the petitioner herein. Mr. Rajbobhia has submitted that the petitioner is presently suffering several ailments and therefore, without much ado, he is under instructions that in case this court feels it, deems it proper, an enhancement of the punishment by way of fine would also suffice the matter instead of requiring the petitioner to undergo the ordeal of appearing before the learned trial court again to face a higher sentence. Full stop. The learned counsel for the respondent number 2 in all fairness has suggested that an enhancement in the punishment would suffice the ends of justice in the matter. Full stop. The learned APP has suggested that since a child of around 10 years of age had been hit by an adult, the matter may require an enhancement, and therefore the enhancement, if ordered by this court and if satisfied by the petitioner by depositing the fine in the manner required under law, the ends of justice could be met in this present case. Full stop. This court has considered the submissions made on behalf of all the petitioners. Full stop. Of all the parties. Full stop. Having regard to the nature of the grievance raised, the injury inflicted, and the time that has already passed, this court is of the opinion that the ends of justice would be met if the petitioner herein, accused in that, what was that case number? In GR number so and so, and the respondent in the appeal number 224 of 2017. Respondent number what? In the appeal number 3 is directed to deposit a sum of rupees 4,000 before the learned trial court, from 2011, you'll pay only 3,000 more. Okay, fine of rupees 3,000 in total before the learned trial court. Full stop. The learned counsel no, which fine on realization shall be granted to the minor victim. No, to the victim. Full stop. Mr. Rajbobhia submits that the petitioner has already deposited the 1,000 which had been required by the trial court to be deposited. Full stop. If such be the case, then the petitioner shall deposit another sum of rupees 2,000 before the learned trial court on or before the 1st of April 2026. Huh? Eh, let- we are just giving because we need to close it. How is 1000 after 15 years going to matter either of the ways? Criminal petition disposed of.
I'm being at the 25 to 30.
Yes, have you found out those two orders? Or আছে? In item number, the first item, that is TRP 8, there is no stay. TRP 8 খন আছে নেকি? এইখনত নাই ন? Different NI case or same NI case? So there is only one stay order in NI case number 3 of 2022. In the rest of them, nothing. Huh. 8 false. No, the first item is item number 20. 25, yes. No. Huh? Item number 25, is there any stay per the order dated? Twenty-one, 2020. Okay. In item number 25, we don't find any stay order. There may be. Why are you not proceeding with the others? Proceed. No stay order in item number in TRP 8 of stroke of luck. 22 to 24. 22 to 24. As prayed for list on 23 to 24. Then why do we need to keep it pending? Why don't you go appear and give your evidence and finish up the matter? Did you have
It's way.
Yes, sir. Hmm? Which one was first? Which one was first? That you did not point out to the trial court. How is it? How is it then? Hmm? We have reached page 160 while we were searching for the rest of it. Done. Read it. Child, you have to take care. Huh? Just a minute. Hmm. What is his reasons for coming to rupees 10,000? Eh? Yes, sir. The first court comes to a conclusion that you are not entitled, that you have left the company of the husband without there being any reason. How can the second court come to a conclusion that no, 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 there was some reason? No. What we are asking you is that you never challenged that earlier order, that you left without a cause. We are trying to see, you want us to see everything by ourselves. Show us. Oh. You were not under, you did not get a stay, did you? Was there a stay? Just a minute. You were required to pay 10,000 per month. Have you paid? We are dismissing it now. We are dismissing it now, sir. Friday. Friday, come up after having complied with the orders of this court. We listen to you. If otherwise already the interim is vacated, then then should we enforce the orders? Mr. Betala, you know very well this kind of things we are not appreciating for a moment. Why? No, that you could have prayed for through a application to this court. You could have done what was required to be done. This court said 10,000 per month and the 1 lakh. Then why not the 10,000? Where have you stated it? Where have you got that? thing? It has been vacated already. That you have not paid anything. Have you paid the 7,000 during this period? Page 78. Huh? From 2023. Hmm. Ah. There are people with bank statements which the income tax cannot touch. Driving four-wheelers, which would make many people envious here. Don't show us the bank statements. Don't show us bank statements. Since you have approached this court, since this court entertained the plea, since you took it upon yourselves not to listen to the court, since the orders of this court has not been complied with by the petitioner, list this matter again on Friday. We are not using the words for dismissal. You are approaching this court and you are not listening to this court. So, no, he suffered it when you filed the petition. Then do it for a person who deserves it. Whatever you are doing today in this court, do it for a person who deserves it. Hmm. 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 Page, sir. Page 43. This is for admission today. Does it need to proceed? Ah, so Mona, that is gone. All orders are gone. 1 year. Yeah, that you have already got by order dated 14 to 2025. That order was stayed. So you got that relief. Eh? Why should it be disposed of after now 1 year has passed of your complaint? You need to prove your right on the land by some other means. Eh? Huh. Your land or his land? Where is the, no, where is the public involved in that? Hmm. Hmm. Between you and him, not between the public. How is the public involved? Hmm. He is trying to grab your land. He's trying to grab your land. There are appropriate proceedings. You are contemplating from 2020, when 2024 onwards. Anything before the magistrate will last only for 1 year.
Yes, madam.
Huh? Yes.
So later one of these this past
Hmm.
island,
Hmm.
they have vacated.
But that was that vacation has been stayed by this court,
Yes,
and that could be done only for a year.
yeah.
For 1 year, it could be done. That 1 year is gone. Which one?
And it be and you directly will complete the proceeding to say complete. That is pending, madam.
What can it do now? From 2024, what orders can it pass now? It has to again call for a fresh police report. It will keep pending there. Not convinced. Eh? Okay, we'll dispose it of requiring the additional district magistrate Kachar to pass necessary orders in complaint case number so and so in accordance with law. In accordance with law. Eh? What you are saying he cannot do, you are asking us to do. You are asking us to do what you said he cannot do. Huh? Okay. Heard Mr. G. Alam, learned counsel, paying for the petitioner. Also heard Mr. P.K. Dekar, learned counsel for the respondent. The present petition had been filed being agreed by the order dated 27/12/2024 passed by the learned additional district magistrate Kachar Silchar in what? In complaint case number 849 within Upor Khoruke M oblique 2024, which was initiated by the petitioner herein. Full stop. The learned counsel for the petitioner, Mr. Alam, has submitted that by an order dated, where was that order? 23/12/2024, the respondents herein had been restrained from entering the suit premises. Full stop. However, by the impugned order at 27/12/2024, the said order had been modified oblique vacated. Full stop. On an approach to this court, this court by the order dated 13/3/2025, stayed the operation of the order dated 27/12/2024, thereby till the next returnable date. Full stop. On 13/3/2025, the interim order was directed to be continued. Full stop. Today, both the petitioners have submitted in tandem, that since more than a year has passed from the passing of the order dated 23/12/2024 and 27/12/2024, the matter may now be remanded back to the learned additional district commissioner to pass final orders on the complaint case initiated by the petitioner after giving both the parties an opportunity of hearing and in accordance with law. Accordingly, full stop, this criminal revision petition is disposed of, directing both the parties to appear before the additional district commissioner, what? Kachar Silchar, to on when? Yes, Mr. Alam. 25th of March 2026 with certified copies of the orders of this court. To stop on such appearance, the learned additional district magistrate Kachar Silchar shall take up such steps as is necessary for final adjudication of the case number 849 Upar Koruke M oblique 2024 in accordance with law. Full stop. Criminal revision petition disposed of. The adjudication in the criminal case be done within a period of 2 months or 1 month. 2 months to 1 month. 2 months from the date of appearance of the parties. What should we say? The interim order continues till then. Yes. কি হল? Yes, sir. Item 35. Yes. You are appearing for? How many respondents are there? Huh? So she has appeared now. You are asking for enhancement, reduction, and you are asking for enhancement. Already granted, yes. Why? The Honorable Council appearing for the respondent number, sole respondent has prayed for an opportunity to file their objections to the criminal revision petition. Full stop. Prayer allowed. List again on. You have any interim in your favor? No. Pick a short date. 25th of March.
36 and 37.
Yes. Huh? You have not read the case. Eh? Why don't you take your instructions? You don't want anybody to appear for the respondent number two. Notice not issued. What are you doing? Yes. At the request of the learned counsel for the petitioner, who is stated to be in some personal difficulty, list the matter again when? 18th of March.
37 and 38.
What was this case? That vehicle? DD got a scroll. আজি adjournment নিদো বুলি কৈছো নহয় ইয়াত লিখা আছে order. Scroll DD আজি adjournment নিদো এইটো কৈছো 5টা বজাত লৈ order দিম. 59. যাক সমাজ. PCR আহিলে? Yes, sir. PCR আহিয়ে পোৱাহি নাই. What about the respondent number 2? When was the TCR called for? Yes, when was the TCR called for? By which order? Huh? 26/11. When was the TCR called for, sir? Okay. TCR is yet to be received. Issue reminder. List again on 25th of March. Interim order passed earlier shall continue. Any interim stays there? Yeah. That idea. 25th March. 30th of March. 1st of April. You were supposed to get a report, sir. Mr. APP. Report received. Reached again on the 12th of March by the order dated 16/2/2026. The report had been stated to be received and the case diary was required to be retained by the APPs. Hmm. Your vehicle was already, huh? Yes, tell us. Now, what does it say? Tell us two things. One, was the vehicle seized on 9/10? 9/10/2025. Oh, ah, she is before this court. No, no, no. He's going to pay a heavy cost. This IO is going to pay heavily. Do you know why? Hmm? Please, you come to that document. Yes, where is that document where that vehicle was on seized from the roadside? Huh? Please come to page 22, sir. What does it say? Tell us. On 9/10/25, the vehicle is seized by the police. Okay? It is seized by the police. Admittedly, it is still with you. On 21/10, there is another incident of a cow theft. This vehicle is linked to that. How? It was with the police and the police is dealing with these car thieves. Please. Because if this vehicle has been detained for nothing, the IO is going to face a very hard time. Okay, yes, no stay. Huh. Okay. Now we will take down in writing from him that you are under no danger. He will provide all the security. Provide security. No, you provide your own security. You are threatening them. Yes, tell us you want this stay to continue or something has to be done. Where do you want it transferred? To which place? Mongoldoy. Why? Mongoldoy is your hometown. No. Go for some other place. Huh? Then you have to pay the cost for him to come to Gauhati. No, you tell us a place where both of you can go without any cost. Yes, which place you will appear? Travel to Mongoldoy. Huh? Udalguri. So we'll transfer it to Mongoldoy. I understand. This threatening, not threatening, for us to decide, we'll have to call for a police report, this and that. Your case will keep hanging because there is a stay. We were trying to find out if there is a case without a stay. We asked them to go and appear. Immediately, everything will come to a solution. Now everything is stayed. We can't help it. Okay. Okay. Yes, we will do it this way. There is a paucity of time today. This is the matter for hearing on 1st of April 2026. No, 2nd of April 2026. Interim orders passed earlier to continue. Keep fighting. Keep fighting await the outcome of this with your beautiful state of proceedings. Nahile, very nahile. Huh? This criminal petition has been filed by the petitioners, being agreed by the order dated. Uh, being, uh, being, uh, being agreed by the order dated. No, there is no order. Being agreed by the criminal proceeding being OR number DH/5 of 2018-19 BVL 64 of 2019-20, registered under the Assam Forest Regulation 1891 against the petitioner, and a direction to be given to the respondent number 2 to release the vehicle by registration number NL01K5990, which was taken into custody, which was seized on 12/8/2018 by the forest officials of the Dholai Range Forest. Uh, you have written here Office of the Forest Office, Forest Official of Dholai Range Office. Full stop. This seizure was done under the orders of the DFO, Mamit Forest Division. DFO, Kasar. Stop. The appeals filed by the petitioner before the different courts, including the Honorable Supreme Court, had been dismissed. List of the Assam. It is the stand of the learned counsel for the petitioner that since the government of Assam had decided to withdraw petty offences cases under section 321 of the CRPC, the case of the petitioner also required a similar treatment. Full stop. He has referred to a similar case where the accused was discharged on withdrawal of a CR case and the vehicle seized had been released to the owners thereof. Full stop. This court notices that on different occasions, time has been sought for by the forest department, either to have instructions or for an accommodation. Full stop. By the order dated 5/3/2026, it was made clear that no further adjournment would be granted on the next date fixed. Full stop. The matter was called thrice today and there was no representation on the part of the forest department in the matter. Full stop. No reason has been shown before this court as to why the vehicle bearing registration number NL01K5990, which was seized on 12/8/2018 by the Lailapur beat forest officer in connection with OR number DH05 of 2018-19 DVL 64 of 2019-20, page 40 one language is required further. Full stop. In the absence of any cause being shown by the forest department as to why the further detention of the vehicle is required, this court is inclined to grant the relief prayed for by the petitioner to the extent of release of the vehicle to the petitioner by the respondent number 2. Full stop. In the however, for the ends of justice to be met, place this matter again on to 11 তারিখে দিয়ক cause lister নাম তো দেখুৱাই নেদেখুৱাই standing counsel forester on 11/3/2026, on which date this court shall pass necessary orders and the absence of the representation on behalf of the Forest Department shall also lead the court to draw adverse inference. We'll give them a last chance for day after tomorrow.
41.
Sorry? Ah. Okay. Yes. It 41 to কি হল?
41.
The cows were caught on 21/11 or 21/10. How was this vehicle connected to the case? This vehicle. Tell us. The police takes a vehicle. Someone else is stealing cows. This vehicle is linked with that vehicle, that incident. Then this IO must have been using the car.
Yes, after yes, operations.
It was shown roaming around, na? Why was the vehicle roaming around? Call him on Wednesday. Thursday. Go and you make an application to the we'll record it. Heard Mr. So and so learned counsel paying for the petition. Also heard Mr. So and so the APP full stop. The learned APP has submitted that as per the report submitted by the investigating officer, the vehicle is no longer required for further investigation with regard to PS case number of 2025 full stop. Accordingly, the petitioner is directed to appear before the investigating officer on Wednesday. Wednesday is 11th. On 11/3/2026 and on submission of proper documents regarding the ownership of the vehicle, the same shall be released to him by taking such surety as the IO may think fit. No, then he'll ask for a surety of 7 lakhs or 8 lakhs. Doesn't appear to be a good one. And the petitioner's surety to kati diba, appear before the investigating officer with proper proof of ownership of the vehicle and shall execute a bond of rupees 10,000 for production of the vehicle if required during the trial, if such trial is taken up against the Mukalmua PS case number so and so. It is observed that the vehicle had been seized on 9/10/2025 and the Mukalmua PS case was regarding an incident which occurred on 20/11/2025 full stop. On the said date, from the records available with this petition, it appears that the vehicle was in the custody of the police authorities of Adabari outpost under Mukalmua police station full stop. The investigating officer of the case shall appear through what? Should we call him through VC or should he come here personally? Personally on no shall furnish a detailed report as to how the vehicle which was seized on 9/10/2025 was connected to an offense which allegedly occurred on 20/11/2025. 20/11/2025. Full stop. The I shall also furnish in the report the details as to whether after seizing of the vehicle, the same was kept in the custody of the police station or had been used or allowed to be used or during the period under which it was in the seizure of the OP. Have it. Why should they seize a vehicle and then use it for personal this thing? Do you know how it happens? This is not of this state. I'm not talking about this state. There has been an instance where a car was recovered from a marriage party which the police personnel were attending. It was a seized vehicle. And they were attending a marriage party in that seized vehicle. So the owner of the vehicle, he goes and he lodges another FIR that my car is stolen and I've seen it in so-and-so marriage party. So the other police station goes and arrests their own persons. This is what happens. The vehicle was with you. Why is it entangled with the other case? Have a report. After that, we'll see. The copy of the order be furnished to the learned APP. You have understood what we want to know from him? If he does not understand the order, kindly make him